So welcome, everyone. We're going to wait just a couple of minutes here to get everybody going. Okay, so Matthew, if you want to go ahead and say the logistics, and then we can get started here.
Good evening, everybody. My name is Matthew. I'm the tech support on this phone call here. So that means if you have any questions for the speaker, please put it in the chat. If you have a question, but you don't want to reveal who you are, you can leave Petronella or Sherry Smith a private message instead. You can do that in the chat function. Just make sure that you target them specifically. We are going to be reading every question. We won't obviously be able to get to them all. If you have any needs in terms of tech support, reach out to me personally. My name is Matthew Broderick, like the actor, and I've got tech help in my name as well. So that should be it. Is that all, Petronella?
I think so. Thank you, Matthew. And so the questions, if we can get it out to Sherry Smith, because I'm going to be looking at different things. She would be, her and Amber would be the ones responding to those if there's something, that we need right away. So I just wanted to make sure that everybody knows that, any questions, go ahead and put it in the chat and we will do our best to get through them. We'll see what we can do tonight. But anyway, with all that, we're going to go ahead. I'm going to try to introduce a little bit about Attorney Tyler Smith. Well, I don't know. I don't have time enough to go through everything that he's done, but he is a graduate of University of Oregon, and he earned his Juris Doctorate from Willamette University College of Law, and that's in Salem. Tyler has experience in major high-profile legal disputes. He has experience working with government agencies, both the legal realm and also making public policy, which is huge for those of you that are in government and know about what we're about to do here. He has been in the forefront of many significant changes to Oregon law via the Supreme Court, Court of Appeals, and through legislation. I don't know how many of you know this, but Tyler is also a former Army combat engineer and attended the Oregon Military Academy. Thank you for your service, Tyler. So why are we here? A lot of us on this call come from different realms. We are firefighters, we're police officers, we're long-term care workers, people from the DD world, from adult foster care home, from professionals, doctors like PAs or nurses or CNAs, teachers, state workers, anyone that is mandated to get a vaccine and as a condition to continue their employment. So we're here to talk about vaccine mandates and exemptions. So I'll let Tyler take it from here and kind of go through the different questions, and then if there's any question and time at the end, we'll go through if there's additional questions. Tyler, please take the floor. Thank you so much for being here.
Thank you, Petronella. I just want to first give a shout out to Petronella and Sherry and Amber for setting this up. This was Petronella's idea. Let me give a little background about what we're going to do tonight, what I'm going to do, and why I'm doing it. I have explained this to many people, and many of you probably called into our office and were asking for legal assistance. And I told this to Petronella. I said, we've had hundreds and hundreds and hundreds of people call into our law firm asking for advice, asking for a consultation, asking for, sort of the just generalized attorney-client interview of as far as what can we do, a consultation. And I told her that there's just too many. We have 4 attorneys, so we're sort of a medium-sized law firm. There's a lot of one-person law firms out there in the world, but we don't have the capacity to handle 400 and 500 consultations. If you could imagine, that would be 500 hours already in the last 2 months that we've just spent on telling people, what are my rights? What do I do? And that conversation. So Petronella had the great idea, why don't you do it once? And we'll broadcast it on Zoom, and everybody can sort of get the idea of what your best recommendations are. So that's what we're doing today. I'm going to treat this as if any of you folks is in my office, sort of asking me the basic questions, and treat it like an initial client consultation with regards to, what does the Constitution say? What are these statutes? What about the forms? And we have gathered, Petronella and Amber and Sherry have gathered most of the main Q&A questions that we've seen asked in various other forums, from schools to nurses to firefighters to police, and then other experts, other attorneys, other lawsuits, things like that that have been out there. So that's what we're going to do in a little bit. I'll start going through most of the questions. What we'd like you folks to do is if you have additional questions towards the end, we're going to try and get done with my basic summary by about 5:45 so that there's time for maybe some individualized questions. But also want to make sure that everybody knows what this is not. I'm an attorney, so I'm paid by people to make sure that we're protected. I'm covering my own CYA here. I am not anyone here's specific attorney today. It's super easy to create an attorney-client relationship. So I want to make sure that, any of the advice that I'm giving today is sort of generic, is my best advice. But in reality, as you'll see in a minute, most of the legal matters relating to the vaccines, particularly the exceptions and the accommodations, are on a case-by-case basis. What a case-by-case basis means based upon your individual situation, particularly with regards to the accommodations, whether what you submit is a medical exemption or a religious exemption, or whether you're subject to potentially needing them to have an accommodation. So I mentioned that in advance because it really is truly and properly under the existing Supreme Court precedents, a case-by-case determination on whether somebody can be exempt or not. So with that said, I'll probably repeat that, but the two things that I'm going to cover tonight is the Q&A on the basics of the law, and then secondarily, what else can you do? So assuming that none of the lawsuits win, assuming that there's no change by Kate Brown and revocation of this, what should you do then? What can you do? So the first thing is, if not everyone is covered by this, let me start with the basics. First of all, right now, the schools, healthcare workers, and state executive department are covered by this, by the various, there's three main administrative rules. And they are, well, actually the state workers, the executive workers are covered by an executive order. The schools, the healthcare workers are all covered by administrative rules. So one of the legal distinctions that's important for everyone to know, and will ultimately be important for the Court of Appeals and circuit courts to know, is that administrative rules are subordinate to statutes. And of course, they're all subordinate to the Constitution. But all of these have either executive orders or administrative rules. So there is some question. People have talked about what is an exemption versus an exception. Well, exempt essentially means that the law doesn't cover you. You're exempt from that law. Right now, for instance, there is no vaccine mandate. There's no administrative rule. There's no executive order that says attorneys have to get vaccinated. So I'm exempt. This law doesn't apply to me. Now, people have talked about what is an exception. I'll get into that much more later. But an exception means the law applies to you in general, but for some reason outlined in the law, you're exempt from complying with it. So, with that said, it's important to know if you're covered. Are you covered by this? Are you in one of the industries that is being compelled to be vaccinated? So if you're not, great. Support those who are. If you are, okay. So the first question is this constitutional? People say, how can they do this? Isn't it my body, my choice? How can they do this under the Constitution? Well, the way the Constitution operates. So in general, the answer to that right now, since 1915, in the Jacobson case that people have talked about, the United States Supreme Court said yes, under a state's general police powers, under at least some circumstances, the 1915 smallpox circumstances, the government was allowed to compel vaccination. Now, there are some serious arguments that can be made that case, one, is old, two, the legal standard has changed since then, and three, shouldn't be complied with anymore. But that is currently still the binding and precedential law. And what that case was essentially there was one town that wanted everybody in their town to get vaccinated because smallpox was coming and it was, you know, harming a lot of people. So the general constitutional framework is that yes, governments under the police powers can make some be vaccinated. And so there are ways to challenge any government law. Basically, in a nutshell, there are 3 levels of review when anyone challenges a government action. There's a thing called rational basis review, which is the very lowest level. In order to overcome a rational basis review, essentially the government has to show that the law or the government action sometimes is directed at a legitimate government interest, and that the law is actually serving that legitimate government interest. The opposite, the converse of that is that the law is arbitrary and capricious. It's not, it's sort of fabricated, it's made up, it's not actually serving any legitimate interest. So that's the rational basis test. And that's what most scholars will say applies to vaccine mandates. Well, as we know, since 1915, there's been a whole bunch of other cases that have said people have medical rights to medical privacy. Even the abortion debate have said that you have a right to personal bodily autonomy, other things like that, which have given rise to either intermediate scrutiny or heightened scrutiny, or it's actually strict scrutiny, which means that the government has to prove more than that. So there are some arguments being made out there that the government should have to prove more than rational basis, more than just a legitimate government interest in order to compel vaccines. But those cases have not made their way through the courts yet. So until and unless those get through the courts and prevail, we're all faced with what do we do? How do we keep our job, or how do we keep ourselves safe and try to comply with the law? So that gets to the exemptions. So there are multiple levels of law that apply to everybody. So many people don't know this. We have federal law that applies and can give you protections, can create obligations. We have state laws that apply. There's both state statutes and there are state administrative rules. So there's everybody's governed by many, many layers of law. It's insanely confusing. But for purposes of this, there are many laws that apply here that's when you're looking at your own situation and your personal individualized situation, you're going to want to comply with all of these laws. And in reality, the employers are the ones that have to comply with these laws. You're setting yourself up by filing for an exception, by asking for an accommodation. You're setting yourself up as somebody that fits into the categories, potentially, assuming you fit factually into one of the categories of protected individuals. So all of these things, for instance, asking for a religious accommodation or seeking a medical exemption, all of those put you into, if those facts fit your scenario, they put you into what you would call a protected classification. There's Title VII of the Civil Rights Act, which prohibits discrimination based on a religion, sex, gender, various other things, and disability or medical conditions. So if you fit under Title VII of the Civil Rights Act, your employer can't discriminate against you based on that protected classification. The same thing is said for some things in education. The same thing is said under our Oregon laws. Oregon Revised Statute 659A prohibits discrimination in employment in the state of Oregon based on the same grounds. You can't be discriminated against in Oregon based on your religious beliefs or your medical conditions, disabilities, things like that. So that's where and why these accommodations, exceptions come about, is that state and federal law protect people from being unlawfully discriminated against. So how do you fit yourself into those kind of categories? Okay, so the first thing was with exceptions. So people have raised a lot of questions about what is the difference between an exemption and an exception. Well, in all reality, so the term exception here is only really coming from the Oregon administrative rules. The state of Oregon has passed these administrative rules that say, employers cannot employ people that have not been vaccinated after October 18th unless they fit into one of the exceptions. So the exception here, the word exception, is simply a creation of the state that matches with their rule. Okay, so it really doesn't matter what you call it, but the state is calling it an exception because it's in a one way that somebody would not have to follow the general rule, which is employers must have their employees vaccinated before October 18th. So in order to fit under one of the exceptions under the Oregon Health Authority's rules, you sort of have to follow their process. Now their process, here's where it gets a little bit tricky. Oregon Health Authority has set up their process and their forms. Well, hypothetically, if their forms and their process did not follow federal law, then the state of Oregon's process would be preempted, invalid, unlawful. So your best, the reason I preface with that is people are best to have some sort of submittal to their employer that complies with both the Oregon Health Authority requirements, their exception process, and federal law. Federal law does not require a specific form. Federal law does not require specific language. So what does federal law require? And what does the Title VII require, Oregon discrimination protections require? So those say that if you have essentially for the medical exemption, if you have a bona fide medical reason that you cannot engage in some activity, whether it's a job, whether it's activities at your job, or whether it's taking a vaccine. If you have a doctor, if you have some sort of a medical condition that a legitimate licensed doctor can say, it is not safe for you to take this vaccine for reasons X, Y, and Z, then in all likelihood, that is a very compelling case for the employer to grant you the exception under Oregon Health Authority's rules, or even the state civil rights or the federal civil rights laws. Because if they don't, here's the real trigger. If they do not, every person that is asking for an accommodation, whether it's an exception through the state or an accommodation for federal government laws, is essentially setting themselves up to potentially have a claim against their employer. It's a little bit of a head scratcher and sad that it's actually, that's what it's setting up, is a potential claim against your employer, because the employer is not really wanting to do anything wrong. The employer is not really trying to do anything wrong, but the employer is the one here that's being compelled to take the action that might be in violation of federal law and state law if you should have been entitled to an accommodation or an exemption or an exception. Okay, so what should the employer do? Well, the employer, for every person, the reason I say you should have both, and I say two, so I want everybody to be clear. My recommendation is to both fill out the OHA form, but you'll notice that the OHA form does not give much room for any kind of details. It's particularly for religious accommodation requests, for the religious exception. They want to know, and I've heard that some of the hospitals are sending follow-up questions and follow-up questionnaires. Well, that's because they don't give you any room on the OHA form. So I suggest that people fill out the OHA form and submit your own independent, either religious accommodation request or medical exemption request in a letter. There are forms that are floating around. The folks that have called into our office have been sent a sample of what one might look like, and there are many good ones around. But the thing you're going to want to keep in mind if you're doing your own religious exemption letter or medical exemption letter is that you need to have in there enough detail to show what the criteria are. The criteria I mentioned before with regards to the medical exception is a genuine doctor or medical professional saying that for whatever condition you have, it's unsafe to get the vaccine. On the religious side, it has to show that you have a sincerely held religious belief. That's the legal wording. A sincerely held religious belief that prohibits, or practice that prohibits you from the event that you're asking for the accommodation for. Here, the taking of an injection of a vaccine. So what the law says is when you're at a sincerely held religious belief, now this is tricky, and this is the way the law works because it's not obvious to a layperson. But there are two aspects to this. There's the belief, and then there's whether it's sincerely held. The government cannot test whether your belief is your belief, whether your belief is valid at all. They're prohibited from doing that because that's the government saying one religion or one belief is true or false, and the government has to stay out of religion. But the government can test, and then on the flip side, your employer could test whether it's actually sincerely held or not. So if somebody was, wholly making it up, lying, inventing their religious accommodation request, and they didn't really have that belief, and so it wasn't really sincerely held, it's possible to legally be denied your religious accommodations request. But what they can't do is say, we don't believe that, Jesus is the Son of God, so any faith on him is bogus. No, the government cannot do that. Therefore, your employer cannot do that to be in compliance with the law. Now, so those are the two sort of the tests, and then why I say to particularly on a religious accommodation request, have the level of detail, have some explanation of what the religious practice is that you would be violating, or what your religious belief is that you'd be violating. For a lot of people, it's the fact that all of the vaccines were tested and or used in some way, shape, or form aborted fetal cell lines. And so for many people, that's the key. And there are a few different degrees of detail that I've seen out there. There is one on the internet that somebody put out, I want to say it's Liberty Counsel, but I can't remember exactly which organization it is, that literally goes through each of the cell lines and their usage by the test number of all of the aborted fetuses test numbers. And that's extremely thorough. And it's out there, it's publicly available. So if you're basing your questions and your concerns based on the abortion issue and the use of baby parts and fetuses, you could look that one up. There are other types of religions that have different practices and different beliefs that should, under federal law, and have been tested under the EEOC for being, legitimate practices and beliefs and those kinds of things, be sufficient to justify a religious exemption or religious accommodation. Those are the kinds of things that go on a case-by-case basis. So again, I recommend doing both OHA's form and your own individualized religious accommodation or medical accommodation letter explaining your scenario. The doctor one is certainly going to require some justification. So if you see something that says we need something from your doctor or medical report, you're probably going to need to provide that. On the other hand, legally speaking, there is case law out there that, for instance, the cases and analogies are somebody could have converted a week ago to whatever religious practice they're doing. And they may not have a religion that is practiced inside of a building or with a priest or a pastor or some sort of a leader that can sign the form. So federal law and EEOC rulings do not allow the requirement that you have some sort of religious leader sign off and say, this is our faith. The Oregon Health Authority one seems to ask for that, and that creates a little bit of a conflict. If you can get that, I would certainly say go ahead and get it. If you can't get it, still fill out the form. I've had people ask about they don't want to sign the form. No, sign the form. Make sure you complete all of the administrative process that your employer or OHA asks you to do. If you don't, you're giving them an easy out. They can say, no, we denied it because you didn't complete the materials correctly. So the reason you want to fill out all the forms and ask for your religious accommodation, your medical accommodation, medical exemption, religious exception, is because if you are wrongfully denied, again, you would have a basis for an EEOC claim, an Oregon discrimination claim under ORS Chapter 659A, and those are your rights. Those are your civil rights and statutory rights. Now, what they need to do, here's goes further. Under the EEOC guidance and general practice for religious accommodation and medical accommodation, they need to know more about your situation. If an employer says you're terminated and does not do any kind of conversation, collaboration, discussion of what kind of accommodation may allow you to continue to work there, what kind of an accommodation may allow you to not get vaccinated and still keep their workplace, safe. They don't have any kind of conversation. That's a serious problem for that employer. It's because, as I mentioned before, it's individualized. There needs to be an analysis between the employer and the employee as to what accommodation might work. It may be under some circumstances, they say there is just no accommodation that can work. And the standard there is an undue burden. If the employer can, after a lawsuit, essentially, or a complaint or a lawsuit, show it would have been an undue burden, just so onerous on that employer to figure out some way to keep you working there, that it just was absolutely unreasonable, then they can win a suit. Then, your religious exemption, your medical exemption simply didn't comply under the law, wasn't enough. And that unfortunately could be some people. But there are many jobs, there's folks in some departments of the state government that have been working remotely now for a year and a half. And so for them to be denied and not be given an accommodation because they can't get vaccinated when they're already working from their house would be probably a slam dunk case. Somebody like that would probably win their lawsuit and their challenge against it. So it's a very individualized determination. You should complete all of the administrative processes and forms, both the OHA form and your own form. Now, people have said, what if my employer has some sort of a system that doesn't allow me to submit my own form? It's just a checkboxes, or it's just on a computer screen, something like that. Then my recommendation would be you print them out, physically deliver them to your employer, preserve some proof that you delivered those requests, whether it's an email copy, whether it's a certified return receipt, whether it's somebody taking in 2 copies and having somebody stamp your exception request and religious accommodation or medical accommodation, stamping it or signing receive, something so you can prove that they got it. Because if you turn that in and the next thing you know, you're terminated, that employer is going to have some serious explaining to do to get around the fact that they probably didn't follow the law. Okay, let me go through some more of the questions here. I've covered exemptions, exceptions. Again, if they don't accept your forms, then they're probably in violation of the discrimination statutes. The law requires them to basically make the consideration of whether you fit into one of the exceptions to the law, the Oregon Health Authority law. And if they terminate you based on your religious beliefs under the Civil Rights Act, then you've got an automatic discrimination claim based on religion. So again, if they don't even allow you to turn it in, the employer is going to have some problems. But again, try to turn it in and get proof that you turned it in. Is it an invasion of privacy and discrimination to question your religious belief or ask your pastor, ask for a document from your religious institution? Invasion of privacy, no. But again, I've covered that sort of, where the government doesn't get to determine which religions, which beliefs, and which practices are actually religious practices. They can only determine whether it's sincerely held. So here I'm reading from some of the questions. I'm going to go through these. I know we're 32 minutes into it. I'm going to do another 15 minutes to get through most of these questions, and then we'll open it up some. Will they be liable for getting people sick if they sign the form? Would the employee be liable for getting somebody sick if you sign the form? No, I don't believe so. Or will the employer be liable for getting somebody sick if they allow you an exemption? No, they're complying with the law. They would not be. So here's one of the tricks. Obviously, we all know that people that have been vaccinated are still carriers and spreaders, and people that have not been vaccinated are still carriers and can get people sick. So, that's pretty yet to be determined, but I don't think that there's any specific extra liability for somebody being granted an exception or accommodation than anybody that wasn't granted an exception or accommodation. So no specific liability would be my thoughts on that. The next one, my doctor recommends the vaccine, even though there could be medical side effects, but won't sign or acknowledge or approve a medical exemption. So what the doctor would need to do would be to give you the medical advice. The doctor does not give the exception or exemption. All the doctor does is give you medical advice. You would then take the medical advice, the opinion from your doctor that states, due to you having this condition, they don't recommend getting the vaccines. I know there's an individual out there that just in the last few weeks did not want to get the vaccine, got the vaccine and had a nasty, horrible side effect to it. That was, I think, paralysis was the result. So this stuff is coming out. And so you need a medical analysis. What do doctors call that? A prescription or not a prescription for pharmaceutical, but a diagnosis. You need a medical diagnosis that says you shouldn't get the vaccine. That's what you would need. Here's one that I do not know the answer to. Somebody asked, how can they require me to get vaccinated if I'm pregnant? My unborn child isn't subject to the vaccine. Great question. That person I might want to talk to. There are some lawsuits in the works. That raises some very interesting questions there. Natural immunity. Can they require me to get vaccinated if I've already had COVID and I presumably am naturally immune or now immune? There was already a lawsuit. There's a group called Freedom Foundation that has filed a lawsuit in Oregon claiming that it does not meet the rational basis standard for the government to require people that have already have had COVID and have an immunity to still get vaccinated. So that's out there. That's already being challenged in court. But right now, yes, under the administrative processes, you would still need to follow the administrative processes, ask for your exception or your religious accommodation in order to not get terminated. How can they enforce a vaccine to employees that don't have any effect on clients or others from not getting it? So that question goes directly to one of my first things is, are you exempt from these rules anyways? Do these rules not apply to you? Well, specifically for the example might be, say you're a police officer and you've been injured. And so you only work at the police department. Maybe you do paperwork at the police department and you're never going to go into a healthcare setting. The healthcare administrative rule has some limitations on it. It's only people that are providing direct medical services in a healthcare setting. So a police officer that's maybe no longer on the streets or doing patrol should be exempt from that administrative rule. Maybe the police department, the local police department doesn't know it. Those are things that you could point out to your employer and say, hey, look, I'm exempt from this rule because I don't go into a healthcare setting and I don't provide direct medical services to anyone in a healthcare setting. That person would potentially be exempt from the entire law. Maybe you're a teacher that only does online classes and only has ever done online classes. So your only role is online classes, maybe a charter school. Somebody like that might actually be exempt from these rules and they're not apply to them at all. So from that perspective, there could be people that are completely exempt from all these rules, but that have been threatened to be terminated. My recommendation is do not quit. This is a big one. Do not quit. We do not know yet. There has not been adjudications that I'm aware of with the Oregon Unemployment Department on whether being terminated for not getting a vaccine would still enable somebody to get unemployment compensation or not. So do not quit. If you quit, in my professional opinion, that would weaken your case for a civil rights discrimination claim under the federal law or the state law. So I definitely recommend not quitting. Is it legal for them to consider, says willful termination if I don't sign the exception forms they sent to you? Again, yes, I think you need to complete their forms. Follow the administrative processes all the way through, gives you your best chance of having a successful case if somebody violates the law with respect to your circumstances. This one, I've been threatened with disciplinary action up to and including termination if I don't sign up for weekly testing. If I'm terminated, what should I do? Continue going to work. Okay, so let's say you receive an accommodation. Your employer says, yes, you can keep working here if you do A, B, C, D, E, and F. Well, the legal test is, are A, B, C, D, E, and F reasonable accommodations? If they're reasonable, and this is where a court, the EEOC, a state circuit court, or a federal district court would make that kind of factual determination. Did what the employer offer you, was it a reasonable accommodation? If you say, no, that's not a reasonable accommodation, you're making the choice and you're drawing the line in the sand that says, what you're offering me is not reasonable. I think you're in violation of the law, so I'm not going to take it. And then you're left to your legal remedies. If they offer you an accommodation that maybe you don't like, but you're willing to do it, then you need to stick by it. You need to stick with it. So that would be for the weekly testing. If one of the accommodations is weekly testing or wearing a mask or a face shield or something like that, or, I've heard some fairly onerous accommodation requests. There's the public one about the fire department in Corvallis, pretty onerous. But ultimately, that all comes down to a legal analysis, EEOC or a court of law, whether that was reasonable or not. So I would say, as long as if you're not ready to draw the line in the sand and say, I'm going to court, then you need to follow the accommodation that's requested. Maybe negotiate on it. But that's the kind of conversation that's mandatory and legal for the employer and the employee to have this back and forth about what kind of accommodation could work for the employer and could work for the employee to see if there's some grounds that are reasonable. Do I recommend filing unemployment after October 1st, since our last day for who knows how long? No, I don't believe you can file for unemployment until you're actually out of a job. So you would need to wait till you were terminated. Unions are refusing to sit down on meetings with HR to represent its members. What do we do? How can unions be held accountable to dues paying members? So all collective bargaining agreements and state law have a process for going through that. There's a grievance process. There's appeals to the grievance process through the union process. You definitely need to undertake that process. But then again, everyone that has a contract as a membership of an organization, whether it's a union, whether it's as an employee, you have contract rights with respect to that organization. And those contract rights are certainly always enforceable in a court of law. If there is something that is clearly, for instance, you have an employment agreement that says you're going to be employed from August 1st of 2021 until June 1st of 2022 as a teacher, you've got a contract with that school and they terminate you, that creates a conflict. You've got a state administrative rule that says they can't hire you, and you've got a contract with that school that says you're going to be employed. Those questions have not been answered and will need to be answered in court. So with respect to the unions, the same thing. You've got a collective bargaining agreement. There's remedies under the collective bargaining agreement. Do those. Got 3 more minutes and 4 more questions before we'll try and open it up here. Oregon law prohibits hospitals from mandating a vaccine. So what legal authority do they have to enforce it? There's 2 specific laws relating to that. One of them says that healthcare workers, first responders, those folks cannot be mandated the vaccine unless some other law mandates the vaccine. Well, the downside is right now we have what is truly and accurately described under the Oregon legal system as a public health law, these administrative rules. They fall within the statutory definitions of laws because they're public health laws. So that gives the Oregon Health Authority the excuse to say that now the healthcare workers are covered by another law other than ORS Chapter 431 and mandate the vaccines. However, the other side to this question is there is also ORS Chapter 431 has another statute in there that says that people will be free to choose the doctor, physician, care provider, or treatment of their choice. Treatment. Well, there's not been a case that's adjudicated and defined what treatment means. But ORS Chapter 431 does use the term that you should have the ability to select the treatment of your choice. So that's something that certainly soon will be litigated. What does that mean? People make the argument that the vaccines are actual mRNA treatments. People make the argument that CDC is changing the definitions. All of those things are probably going to be adjudicated here. There's cases here in Oregon, there's more cases coming in Oregon, and there's cases all around the nation. So that will probably be answered in the courts. How will employees continue working if a lawsuit is filed? Do they need to be fired? Most lawsuits start with something called a temporary restraining order or a preliminary injunction if they're trying to, or even a stay request, if they're trying to stop the enforcement of the threatened action while the lawsuit is going on. So unless or until one of the lawsuits prevails on getting a temporary restraining order or a preliminary injunction or a stay, then the law stays in effect and the law continues to operate as it's written until maybe the end of a case. Maybe some judge rules that somehow the law isn't valid or is partially invalid or something like that. So the law will apply to everybody as written unless or until someone gets a stay, temporary restraining order, or a preliminary injunction. So that answers that. If a lawsuit is filed, will that stop the October 18th mandate deadline? Not specifically, but it would if somebody gets a stay, temporary restraining order, or preliminary injunction. Is there a specific lawsuit just for teachers that I'll take on? I have 2 clients. So right now I have 2 specific clients, well, 3 actually, that have engaged our law firm to prepare a lawsuit. We are engaged in that. I am not going to get into the specifics of that, but the filing of that is imminent. That does include arguments that would protect teachers, that would protect firefighters, police officers, anyone covered by both the healthcare rule and the public teacher or the teaching rule that have been passed. And there's multiple grounds for that lawsuit. I'm not going to get into that legal strategy, but I will let you know that the 2, there's the 3 clients that we have. It's all public information. There's groups that have come that are new or old that have come together to try and fight this. One of them is called a group called Free Oregon. There's an executive director, Ben Edel, who his organization is furiously fighting against these things. There's another group called Mandate Free Oregon, which is a new group and is vigorously fighting these things. They've already participated in one of the lawsuits that is from a gentleman from Salem, the attorney from Salem, that's largely police involved, but some firefighters and other folks there. There's another group for Doctors for Freedom. Those 3 groups are our official clients. Like I said before, anybody here on this call know that you're not our official client. I see there's been people added, so I'm going to repeat myself on that. You're not our official client. We're simply trying to help out. Quite frankly, like I told Petronella, I felt bad that I couldn't do 400 or 500 consultations like this to explain all these. People kept asking me the same questions over and over and over. And so we did an email out to people, giving them some of the basics. But I wanted to go a little bit more in depth. I could do it sort of once and give people some of the basics that they should consider. Now, I do know of some law firms that are taking individual cases. So if your exemptions are denied, if your accommodation is denied, there's a couple of groups that I do believe are taking individual cases. I believe Kevin Mannix's law firm is taking cases. I believe there's a firm called Rugged Law that is taking individual cases. I believe Freedom Foundation may be taking individual cases. And so some of those groups might be worth a call if you're denied or when you're denied or anything like that, if you need to take an individualized case. It's possible that our firm would in the future, but we have too much other stuff to go to be taking individualized cases at this time. That's why I'm doing this for free, just trying to help out the folks that we're directly or indirectly connected to. Other questions? Now, there's probably been some online. Sherry, Petronella, Amber, let's see.
So
Wanna
Tyler,
jump in here?
I just want to follow up, you know, and you made it pretty clear. The question that I keep hearing over and over, the OHA form that we're all getting, you're saying to fill it all out, but also fill an exemption form that you actually explain why your religious or medical reasoning is. Some of these like care homes or the DD homes, we already got approval to actually go through and approve our own employees, our own. So what is your advice of that? Do we still do that, or what is your take on that?
Yes, so the onus is on the employer. So again, if you look at the fines and you look at the restriction, OHA's rule specifically says the employer may not employ people that are unvaccinated. So if the employer themselves are willing to take the risk of using a different form or complying, you know, with the law that would be under effect under the civil Title VII of the Civil Rights Act and those kinds of things, those don't require, like I said, those don't require a specific form. So OHA's form might be sufficient and probably would be sufficient for Title VII as well. But again, it doesn't give much room for the details that are sometimes necessary. So my recommendation, OHA form might be fine. If the OHA came to you or some other organization came to the employer and said, why did you grant an exception or an accommodation to this person? They didn't use our form. You know, that would be sort of an enforcement thing that they might go against the employer. So, you know, if you're an actual employer, I might recommend that you have your employees do the form anyways, because that's what OHA's rules are and their quote unquote law, the public health law requires. But I don't believe, especially under the federal law, that that particular form would be required. So that's why I say do their form and something with some more detail that would allow you to point out the facts that justify in a potential later case. You're basically protecting yourself by showing that you do have sincerely held religious belief or a bona fide medical condition that prevents you from taking the vaccine.
Fair enough. Sherry or Amber, do we have a question that we can bring up? We have approximately another 15 minutes or so.
Absolutely. There are two items that I took notes on, a few different comments regarding the fines following the October 18th. We've got some people here who are both employer and employee, but there are many people questioning about the $500 fines and information about that.
Yeah, $500 fine. I mean, the employer would be fined. I mean, that's what they're threatening. So this is what it is. I think that, so, you know, back last year with the mask mandate, there was the same enforcement provision where violations of public health laws can have a fine. And it was the same $500 fine. There were some, they were highly publicized. Most people remember I think she was a beauty salon in Salem, received a significant fine for multiple days. So that's a realistic possibility for employers that don't comply with this. So, I mean, the law is the law. And I think until it's overturned, anybody would be taking a risk to violate it. That's why I think it's important to, you know, get the forms turned in properly, understand your legal protections, and make sure that you comply with sort of the prerequisites that might be necessary to protect yourself.
I have one other question that came up a couple different times. People asked if I'm terminated for not taking the vaccine, can they deny unemployment?
That has yet to be determined. So the Oregon Unemployment Department makes all determinations on whether you can get unemployment or not. It's a state program with a state mechanism for determining who's eligible, who qualifies, who doesn't qualify. Ultimately, those kinds of cases can be appealed, but it's through the Oregon court system since it's an Oregon state benefit. So if you are denied and think it's wrongfully denied, which I'm sure will happen to somebody if they deny these unemployment benefits, then somebody will probably take that up to the Court of Appeals, maybe the Supreme Court, and that's where you get a final determination. I would say definitely apply. It's yet to be determined whether they will give unemployment benefits or not.
Another question, if the OHA forms, since they are unsecured, have been edited, is that a concern?
If they've been edited?
Yes, from exception to exemption.
Oh, I suspect it's not going to matter if you wrote exception or exemption where it said exception, but I wouldn't do that. I mean, I think that's unnecessary. You know, from a purely legalistic legal dictionary standpoint, I think the right answer is exactly what I suggested. Exemption means the law just doesn't apply to you. Exception means the law applies, but you're following under one of the line items that says you don't have to follow it to the 100%.
And then finally, I just want to add in, oh, sorry.
Go ahead, Amber.
I just wanted to say that I've dropped in the Google Docs that Tyler has graciously made available for religious exemption templates. And so I don't know if you wanted to just speak to that really quick. Those are available in the chat.
So I go ahead.
So, all the employer, again, your employer, it's not Oregon Health Authority that's going to review any of the exceptions unless you work for the Oregon Health Authority. It's your employer. So if you work for the county, you work for the city, you work with the fire department, if you work for the school, it's the actual employer that's going to review these things. See that question out there?
So Tyler, there's been other questions regarding affidavits, and are filling out an affidavit a good idea or necessary?
A sworn affidavit, if that's what people are saying, would only basically provide the same statement of facts that your request would do. When you state these are your religious beliefs and this is why you can't get the vaccine, or this is your medical condition. I think that's the only thing that an affidavit would do, was be to state those facts in your personnel file or your reason for requesting it. So no, I don't think you need any kind of sworn or notarized affidavit at all, because that's not a part of the consideration. It's not a part of OHA's consideration. It's not required for Title VII. It's not one of the official requirements. I don't think it would hurt anything, but it's probably overkill. It's just have this, some sort of a sworn penalty of perjury affidavit.
Okay, next question is, would filing a writ of mandamus be beneficial?
So writ of mandamus, there's two types of writ of mandamuses, and the legal analysis is incredibly complex, but there's two types. The first kind is to compel a government agency to comply with a clear legal obligation. And so if the government agency has a clear legal obligation, like a clerk, like the county clerk to count the votes, something like that, where we know and everybody knows and the law is obvious that they have to do their obligation, that's where the first kind of writ of mandamus is useful, to force them to do what their job is to do. Here, I don't think there's a clear enough obligation, that somebody perform a particular task. That somebody else might disagree with that. There's also another kind of writ of mandamus. There's a writ of mandamus, a special mandamus to the Supreme Court. There's only certain categories of lawsuits that can fit that. And I don't think that's the most appropriate forum or venue for this, because usually writs of mandamus to the Supreme Court are only for things that the Supreme Court has original jurisdiction, where there's certain things in the Constitution that occurred by the Supreme Court. And most of the time they will deny special writs of mandamus to the Supreme Court if it's not something they have original jurisdiction on. So that's my thought on that.
Okay, you may have covered this. I was typing up a bunch of questions. So if an employer is refusing religious exemptions filed and demanding that employees use the OHA form, are they still protected?
Yes, so I think anything that you put into your personnel file in terms of your requests. So again, the scenario is they deny your exception request. They do not give you a religious accommodation or a medical exemption or anything like that, and you decide to sue. They terminate you and you decide to sue. But then all of this documentation is the factual evidence, the documentary evidence about whether you would have a successful discrimination claim or not, whether it's Title VII or OS 659A. So all of that documentation would be in your file, and a court or a fact finder would look at all of that stuff. So if they say they want something more, submit it. It's not going to hurt to have more. The one thing that some legal experts are advising, and I agree with, is you don't want to have mixed motives. It's going to do you no good to say, I think my free speech is being violated by having to get a vaccine, or I think you're invading on my privacy rights by doing that. Those are not recognized exemptions to these kinds of mandates. I think you really, unfortunately, I wish it were otherwise. Unfortunately, I think you can be compelled to do this until one of these other cases wins, unless you have a medical exception, a medical reason, or a religious reason. There's not much else that I think, or it just doesn't apply to you. You can try and convince your employer that if you're maybe some sorts of fire services, some sorts of police, maybe even some sorts of healthcare workers might be actually not within the definition of these rules.
Okay, next question is, for those that work remote in another state, still being potential to be fired on October 18th, how does the mandate legally impact remote workers?
Good question. That would actually implicate more federal laws that I haven't fully vetted, but there's a thing called the Interstate Commerce Act. So where federal law can dictate, where states can only regulate employees and companies in other states to a limited nature. So I think that person might have a unique individualized scenario there where they would have some additional legal claims. But again, it's going to be up to your employer. I would probably, in that scenario, I haven't thought this fully through, but probably look at arguing that these rules don't apply to you because you're actually employed in a different state. If you live in a different state, they're probably having to pay state employment taxes and things from the state you're living in. And so you may not be actually employed in Oregon.
Okay, next question is, I am vegan and the vaccine goes against my spirituality. Am I covered under the religious exemption?
That would be, I think that the EEOC has given a guidance that I think applies to that kind of a scenario. It does not really matter what the religious, spiritual belief is, because the government doesn't get to test whether it's everyday church service or a spiritual belief or something like that. That's not what the government gets to test. So that person very well could have a claim. Now, sometimes those are the kinds of cases that are on the boundaries and on the borders of being legally protected. Unfortunately, the closer you are to a boundary, the maybe more likely somebody would be denied and have to actually challenge it. But I think there's a good chance that that person would be protected.
Okay, if we are on unpaid administrative leave, what documentation would we need to apply for unemployment, and how long can an employer keep us on unpaid leave?
Those are excellent questions. I do not have the answers for those today. I think that the real question would be, is unpaid leave a reasonable accommodation? I don't know. That's a fact. Like I said, that would have to be adjudicated by a fact finder. Don't know whether unpaid leave would be a reasonable accommodation or not. The vaccine mandate, from what I'm hearing is this may get turned into a permanent rule when it terminates. Again, the current vaccine mandate are only temporary rules. They're going to expire 180 days after they were put into place around September 1st. They were all updated. So they're going to expire at some point in time. So how long this unpaid leave goes for, if the temporary rule expires, then it will no longer be law. If they turn it into a permanent rule, I'll have to see what that permanent rule says.
Can my employer force me to resign if I refuse to get the vaccine? I'm being asked to sign a resignation letter.
I would not do that, no. There's a thing called constructive termination. So if you assert a statutory right, constitutional right, something like that, and an employer terminates you for standing up for your own civil rights, essentially, then you might have a thing called constructive termination, where maybe you had to quit, they forced you out. It's called a constructive discharge, constructive termination. And so that would be that scenario where if they literally force you to sign something, you're going to want to have some documentation. If I was advising a client in that scenario, I'd say, make sure you have some documentation that they say, you have to do this or we're firing you anyway. I mean, just let them fire you if that's the route they're going to go, so that you've got your evidence and your documentation that they were the ones that actually terminated you.
Okay, I've got a question that's regarding if somebody is an employer and an employee of a clinic, how does that work?
You're going to need to handle your own exception requests. Then that person's duty and obligation would be to follow the law on granting them. And if OHA or some other agency came knocking, then you have to deal with the risk of the $500 fine if you didn't do something properly.
And the next one is specific to Kaiser. They sent out a letter that they were going to reevaluate previously approved religious exemptions and may reach out for more information. Should we be concerned, and what should we do?
I would be prepared to submit more information. I just found out today from somebody that some of the forms have been used so frequently and not customized at all. The templates and things, some people maybe just not comfortable with computers or writing anything else, that some have said, well, maybe they're doubting whether it's sincerely held belief or something because it looks too formish. So I think people should be prepared to supplement or answer questions. I heard that maybe it was Legacy or somebody was actually sending out follow-up questionnaires. I would absolutely comply with those requests and give more detail. Be prepared to give more detail. If it's a religious exemption that you're asking for, exception, I should say, then understand why, what about the aborted fetal cell lines is objectionable. Or if you're, a vegan or a Buddhist or something that just doesn't inject animal parts into your body or whatever, understand that and be able to at least articulate that to some degree so that you can show that it's a sincerely held belief, to comply with the law.
Okay, here's another remote question. So I work 100% remote, but I'm still being asked to report vaccination status. Is this legitimate?
To report the status. So here's a thing that I haven't covered yet. Private employers, if they chose to, on their own, absent any state of Oregon mandate, could, in all likelihood, require you to be vaccinated. Let's say Joe's shoe shop or Dick's Sporting Goods, maybe something that everybody knows, could probably require their employees to be vaccinated and be employed there, just in the abstract. It might be different to terminate them after they're employed. But so from that perspective, if your employer is on their own, independently, voluntarily requiring you to get vaccinated, that's a larger problem for somebody that doesn't want to get vaccinated. You still might have your Title VII civil rights protections or 659A exceptions. But then for them to ask your vaccination status is probably not a problem. They can probably do that. What raises the problem legally, I think, is if they terminate you wrongfully, terminate you in violation of the exceptions, the religious accommodations, medical accommodations, protections. Or if you have a contract, that's what I mentioned before. If you've got a collective bargaining agreement, some sort of a term contract, those things are probably, again, protected above and beyond what the administrative rules say.
Okay, so this question says, I thought Oregon law exempted all of these groups from mandating vaccinations. What changed?
I think I tried to address that one. When OHA passed these administrative rules, temporary administrative rules, that is the legal equivalent of a public health law. And the prohibition on these groups getting vaccinated said unless otherwise required by law. The unless otherwise required by law condition has now been fulfilled because there is this OHA temporary administrative rule that is otherwise requiring it by law.
Okay. Next is on August 26th, there was a press release from Bend firefighters that mentions that mandates appear to be in direct opposition to ORS 416.433. Can you comment on this?
I think that's the one we just talked about. That's the prohibition on requiring mandates unless otherwise required by law. So, okay. Same question.
Okay. My medical providers refuse to sign my medical exemption forms due to being threatened they'll lose their license to practice if they do it. What do I do?
Well, obviously, every professional has to be genuine and honest, with their advice. So a medical professional should not, phony something up. They really did. If they're, you would think a medical professional that's actually giving bad medical advice, unfortunately, maybe they should be sanctioned. Not that I like that, but you don't want people giving, just like many people don't want CDC or Fauci or anybody else giving bad medical advice. I would honor that medical professional if they can't legitimately give you a medical exemption. If it's arguable, then find someone else that can. If it would be phony for them to do it, I'd say that's the honest, thing to do, unfortunately.
Okay, we have a time for just a couple more questions. Can we refuse the testing? I heard the nose test has antifreeze in it, and a biologist looked and the packaging says it is, or it does contain antifreeze. So can employees refuse the testing as an accommodation?
Yes, you can refuse the testing, but you're still in that negotiation process between is the reasonable accommodation reasonable or not? If you're saying it's unreasonable to have to get tested all the time, you're going to have to do enough other stuff to convince the employer that it's not an undue burden, that somehow your workplace would be safe, even if you weren't testing and weren't vaccinated, etc. So it'd have to fit into that whole catch-all valuation of the whole set of circumstances to can you be accommodated in some other way?
Okay. Another question here is, what about getting an informed consent response first?
So there is a legal argument that emergency use of vaccines is only allowed if the individual taking the emergency vaccine has been told that it's optional. And this is a legal debate. There's the Arizona Attorney General just issued an opinion that differs with the Federal Department of Justice's opinion, where the Federal Department of Justice wrote a long position saying that they do not believe that you have to consent to be forced to have these vaccines. Basically, their argument is you have a choice. You can not work there or get the vaccine, so therefore you have a choice. That's their argument. That's the federal government's argument. Doesn't seem like much of a choice to many people. but that's the informed consent. So under that circumstances, you would have to consent to getting the vaccine because you're supposed to have the option to be out. That's the FDA requires providers to notify the people they're giving EUA authorized vaccines to that they can opt out. But now they're saying, well, it's just an informational requirement. And if they don't do it, it's not, doesn't prohibit them from mandating it. So that's a big legal question right now, whether you have to give informed consent or not. State of Oregon is apparently, by the nature of these rules, asserting that, no, you don't have to consent. You have your choice to either be terminated or get the vaccine. This is essentially what you can read between the lines of the way they put these rules together.
So Sherry, I think we have time for one more question here, and then we'll call it a night.
Yes, and I think there's also, well, why don't we just let Tyler talk a little bit about those who've had questions regarding the funding of the lawsuit.
Yes.
There is a question with regards to how do I know if I donate to Mandate Free Oregon or Free Oregon that 100% of my dollars are going to go to the lawsuit. And so Tyler has also set up an alternative, so I'll let him talk to that.
Yeah, thank you. I do want to cover that, and I do have to leave in a minute. So thank you you ladies have done a great job in getting this coordinated. So yes, as I mentioned before, Free Oregon, Mandate Free Oregon, and Doctors for Freedom are all groups that have retained us, that have, are gonna at some point in time have a legal bill and on our actual lawsuits. Today's meeting is not really about that, but if that's something that you're looking to do, I encourage anyone to support any of those three groups. Maybe you've got a connection or like them or look them up and support those groups. If you're concerned at all, we can, what I told those groups is if anybody wants to support those groups' legal efforts, they can donate or contribute directly to the legal cause. And I would take anybody that sent money to the legal cause, I would just simply take it off of whatever those groups' bills end up being. So the donation would go, for instance, if somebody donated $100, then those $100 would be applied to eventually when those groups have a bill for legal services, it would be deducted off of their bill. So that way, somebody I think commented on one of the organizations to say, well, how do we know it's not going for administrative and overhead and whatnot? So if you want to do that, there's a group called Freedom's Friends, which is a fledgling group that I set up about a year ago in relation to the challenge to the mask mandate, the original mask mandate. It's a fledgling organization that I set up, but I can guarantee that 100% of any donations to that would go to those three organizations' actual legal bills on the suit that we're doing for them. So that could help. But I support those organizations 100%. If somebody's not comfortable with that, they could give just to the legal efforts directly.
So we appreciate that, Tyler. So I want to make sure that everybody knows that if there's any questions about the form that you want to submit with the your OHA form, if you want to send us an email, maybe to Sherry, if you want to put your email down there, and people can ask those questions. This is going to be a recorded meeting, so we will have a kind of a link to that as well. So if you don't mind, we'll forward the link as well.
Katrina, let me jump one more time, and I just want to do, the whole CYA. I'm sure that somebody's going to complain about that I'm giving people advice or something like that. You do know that go and get your own individualized legal advice. I am absolutely sorry, and it hurts and pains my heart to not be able to help all the people that called into our law firm, 400, 500 people and groups with representing thousands and thousands of people that we were not able to give actual direct legal advice to. So do know that my advice today was to attempt to be helpful, almost like a CLE or a webinar, but everybody does need to get, if they can, legal analysis for their own individual circumstances.
Thank you for that, Tyler, so much. And then I know, Amber, you were going to put maybe some websites or where we're going to put that link as well in the chat. That would be helpful.
Absolutely, and I'm going to share one more time the links to the religious accommodation letters that Tyler made available, but please know, as he mentioned, to customize them for you. Don't use them as form. It's wonderful that he's made these available. One of the places that we'll add this recording to and the template letters is this link right there, and there'll be others that we share it out to. We might even just leave it in Google Drive and can try to get that out. If you share your email or drop your email in the chat, we're going to be able to archive this chat. You know, at one time we had about 520 visitors and we have 424, so we've lost some people. But if you put your email in the chat or send it to Sherry privately, we'll archive those and try to get a mass email out as well with the recording.
Okay. Well, thank you very much. I appreciate everybody that's been on the call tonight. A special thanks to Tyler. You have no idea what this meant to all of us. And like I always say, we're all in this together. Let's keep it going, guys. Until next time, I want to say good night to everyone. And thank you so much for being here tonight.